Good morning, everybody, and welcome to HR Breakfast Club. I'm Gabrielle Sullivan, and I'm delighted to be here on, frankly, what's a really nice looking morning from my east-facing office. Today we're going to talk about the topic everybody's talking about, coronavirus, but we're in the HR business. It's a very busy time for us, and so we're going to be talking about some employment law answers to the kinds of questions that HR managers are asking right now. So just a few housekeeping things before we get going. I'm new to webcasting, so be patient if there's any technical issues. I do have a fabulous assistant with me this morning, who of course is minding her social distancing, so you won't be able to see her, but she might pop in from time to time if there's any technical difficulties. I'll do my best in our face-to-face forum, as those of you who come to Bradley Allen Love's HR Breakfast Club will know. I'm quite happy to be interrupted, quite happy to take questions as we go, meant to be an interactive forum and trying to give really practical advice to people at the coalface of HR. That's obviously a lot more difficult in this sort of forum. So the plan really is to take you through some of the basics. From my point of view, some of you have sent in questions in advance. I've tried to cover those off in the course of the initial presentation. And then I'll leave a little bit of time at the end for people to ask questions. Of course, you'll have to type it in and I'll do my best to answer that which I can in the time that we have. And if we need to follow up from there, we'll follow up from there. We'll also make a copy of this presentation available after the seminar to those of you that would like it. So with no further ado, I propose to get on with it. So here we go. Employment law answers for HR managers to COVID-19. Right, so what are we going to talk about today? And I should say, just forgive the slides. Everybody's in a rush at the moment, right? We're doing the best we can in a very fluid and changing environment. So what are we going to talk about this morning? I thought it would help if I just reiterated for everybody the employment law framework that we need to be mindful of when we make decisions about HR, because frankly, that hasn't changed. So we just need to remember to look at those instruments. So I'm going to take you through that. I want to dip quickly into work health and safety in a practical kind of way. And then, of course, move on to issues of labour flexibility, because, of course, that's what we're all talking about. Working from home, leave, what do we do about changing hours or pay? Stand down, of course, is big news at the moment. Let's touch on that. And, of course, finally, the issue of terminations and redundancies. I thought it'd be helpful just to recap on some core points there before moving into a Q&A. So that's what we're going to talk about. Let's talk ourselves through it. So for those of you who come to HR Breakfast Club regularly or occasionally, you might have seen this slide before. It's my favourite go-to employment law slide because it reminds us of all of us of how we answer HR questions from an employment law point of view. So when we've got any question like, can I stand somebody down? Can I vary their hours? Those sort of questions, how do we answer it? The law obviously doesn't cover off on every contingency. So we go back and we go back to our framework and we look at it from that point of view. So it's really important that we remember that, well, we all know employment law is in HR is a difficult business because there's so many instruments that apply to the workplace, but the core instruments are these. Firstly, the contract of employment. Now that can be the express written terms, and relevantly, there are also implied terms in the contract of employment that really will come to the fore here. Two of the obvious implied terms are that employees have to obey lawful and reasonable directions. Now that's going to come up in a second when we start talking about WHS and work from home and isolation and whatnot. but just park that thought for the moment. The other implied term in every contract of employment, so whether written or otherwise, is the dependent obligation that is service that earns wages. There's a lot of implications that will play out in managing coronavirus responses by HR that depend upon that so-called, it used to be called the work wages bargain. I'll talk about that in a second, but the point for the moment is before you make decisions in this space, you need to find and establish the contract of employment. That's the first thing. The second thing is, of course, some of you will have written HR policies, and you should have a look at what they say about where matters currently sit, and of course, amendments might be in order. The third source of instruments, third source in the framework, of course, is legislation. So a contract is privately negotiated, HR policies are firm-wide. Legislation, of course, is either national or state, depending on what the legislation is. But in this case, the WHS Acts, Work Health and Safety Acts, which are territory and state-based legislation, are plainly very, very relevant. Obviously, also are acts like the Fair Work Act, which sets out things like the national minimum standards, governs stand down in large part, and I'll talk about that in a sec. So legislation is obviously that which we need to comply with. And this presentation, of course, talks about the law as it currently stands, and we wouldn't, of course, be ruling out legislative change in response to events as they evolve. So in addition to contract, policies and legislation, you've also got, for some employees, awards. They're award covered, and you have to comply with those. Some awards cover stand down, things like that. You need to be mindful of that and cognizant of it. Finally, if your organisation has an enterprise agreement, the enterprise agreement will, of course, displace the award for the period of operation of the agreement, and you need to comply with your enterprise agreement as far as pay, hours and things are concerned. So just bear that complex framework in mind as we proceed to dip into the actual issues. So that's the framework. I said I wanted to talk about work health and safety, and for those of you who've just joined in, my name's Gabrielle Sullivan and you're with HR Breakfast Club. We're doing our webinar on coronavirus. And we're just dipping our toe into the water of work health and safety, which of course is on everybody's minds. I'm not going to go too much into it because it's a very complicated area. I thought what I'd do is just distill the core points for you. And I suppose what employers need to understand, essentially what their primary duty of care is. Their primary duty of care is set out, of course, in the WHS Acts. Sorry, just bear with me a second. Thank you. The primary duty of care is that employers must ensure, so far as reasonably practicable, the health and safety of their workers while they're at work, workers whose work activities are influenced or directed by it, and that other persons are not put at risk from the PCVU's work. So that's the primary duty of care, and it's worth really dwelling on those words for a moment because that explains that the duty extends not just to workers but to other persons, that other person's safety is not put at risk from the conduct of your enterprise, which is why public safety concerns obviously factor into that. What's really important in that definition, of course, is that what you need to do to discharge that duty is that which is reasonably practicable. Now, obviously, we can't tell every organisation what that means in their particular case, but that's the challenge. That's what you have to work out, right? And there are limits to that which is reasonably practicable, as we're all finding out, right? But that's the obligation. Probably worth reminding ourselves here is that's the obligation on employers. It's true also that workers have their own duties under the WHS Act, and I've summarised them there on the screen for you, and that is that they should take reasonable care for their own safety and for the safety of others. They are obliged to comply with reasonable WHS instructions, and they are obliged to cooperate with your WHS policies and procedures. So to the extent you're getting any non-compliance there, you could at least whip out Section 28 of the Work Health and Safety Act. So that fits in the legislation corner of that framework that I was talking about. So that's what the law says. I thought I'd tell you in a slide what that actually means, if I can. Just, okay. How does an employer discharge that primary duty of care? Well, as we all know in the language of work health and safety, the mantra is that we identify the risk, we assess the risk, we control it, and then we review to see that that's working. There's a whole field of expertise that sits underneath that, as we all know, right? But what it means at the absolute least, as far as I could tell regarding the corona risk, is that at least you should be applying the ACT Health and the Australian Government Health and the Smart Traveller websites recommendations regarding corona as it's updated. So you absolutely need to be doing that. And the other thing is, of course, part of that is ensuring your workers know about that, what you're doing about it. Now, that, of course, is evolving. We're all looking at that site probably way too much. But currently, that at least includes your distancing regime, which is obviously more difficult in some environments than others. The hygiene requirements, issuing of personal protection equipment, complying with the isolation and the quarantine regime that the Australian government has recommended, and of course complying with the bans on travel and gatherings. So we know that. I guess I just wanted to put it in a framework for you and just confirm that that is the source of information. You should be complying with that, and doing that will assist you discharge your primary duty of care as a employer or a person conducting the business or undertaking. I do want to talk about, I'm getting some questions about the duty of care in the context of working from home. I will pick that up. Oh yeah, I've got it covered there. I just couldn't see that I had it there. I had a bit of a panic there. Right, so look, that's WHS. There's a lot in there, and there's more to come, but I thought I'd at least just put that out there for a moment, and I will weave some additional WHS considerations throughout the rest of the presentation. What I want to do now is move to part 3 of the presentation, which is to talk about labour flexibility, because obviously workplaces, depending on what your industry is, how demand's going, whether you might need to increase or reduce labour is obviously a question on a lot of HR managers' minds. But let's start off with the flexibility question that seems to be coming up in my practice a lot at the moment is working from home. What's the story with working from home? So let's start with a few basic questions. Can I direct my workers to work from home for WHS reasons? Can I? Answer yes. As I said to you, as long as that's reasonable, then Section 28 of the Work Health and Safety Act would oblige those employees to comply. Also, as I said right at the start there, it is an implied term in every contract of employment that employees must obey lawful and reasonable directions. So if you need to do it, acting rationally and reasonably, and it seems that that criteria would be satisfied, then you can do it if you need to do it. So yes to that. So that first question is, can I direct them? Answer yes. Second question is, do I have to? Do I have to direct my workers to work from home? And the answer is not yet. Not yet. Whether we'll get to that, it's not clear yet, but you should be guided by the Australian Government and the ACT Health's advice and orders in that regard, right? So that's how you answer that question. And the other question that's come through is, if workers do work from home, does the home then become a workplace for the purposes of these Section 9 work health and safety duties? And we probably already knew the answer to that, and the answer is yes. Work health and safety isn't confined to your home base, your usual place of employment, as it were. It's wherever work is conducted. So if work's being conducted at home, home becomes the source of your, within your scope of your WHS duties. Okay, so some employers are more set up to cope with that than others, but I thought I'd give you a quick tip from how you might realistically discharge that duty, given that it's all very short notice and there's resource and IT constraints and whatnot going on. Remember, you only have to discharge that duty to the extent that is reasonably practicable. A couple of quick suggestions is that for workers working from home, get the employees to do a self-check, quick self-check that their home is safe in terms of particularly exits, slip and trip, that kind of thing. They're the kind of things that tend to happen at home. And somebody suggested you could do a Zoom or a Skype verification check as the employer. So get the employee to do a little, show you around a little bit with the technology that we have, and verify yourself that, yeah, look, okay, the workplace looks safe enough. Okay, so that's a simple thing that it's not going to cost the earth to implement. The other practical tip there is maintaining daily communication. For example, that way you're checking in with people. I mean, that obviously might have productivity reasons you might want to do it, but from a WHS point of view, that way we know that somebody didn't, slip on the floor yesterday and nobody's found them for 2 days, because we've got a daily communication regime. So think about practical solutions like that. And obviously, as part of your working from home policies, you'd want to make sure that employees know that they are to report any home injuries ASAP, right? So that we can address that risk. So there's some practical work from home tips. Let me see. Just a couple of other questions on working from home. Do they get paid while they're working from home? Well, yes. Service equals wages, right? When one renders service, you earn wages. So it will behove employers to consider the protocols they have around reporting, around how contactable they are, what the service standards are, etc. You're paying them, you may as well try and get them to be as productive as possible. The other question that's on a lot of people's minds is what happens if schools close and employees can't effectively work from home, or frankly, or at all. Wow, nobody wants to go there, right? But whether that's going to happen or not, well, it's not up to me. It's potential. It's likely. So I thought I'd ask the question. The answer will be that the employee wouldn't be entitled to be paid in that circumstance as a matter of contract. So that's because if they're not rendering service and they're not able, willing and ready to render that service because they had childcare responsibilities, then they wouldn't be entitled to wages. That's as a matter of contract. Just going back to our first slide where I said to you, consider the framework. It may well be that in your award or your enterprise agreement, you have different arrangements, but and you'll need to honour those if that's the case. But the default position, the generic position, as it were, with it, the law would not require them to be paid in that circumstance. Obviously, that doesn't preclude employers from choosing to be more generous if they're able to do that. Now, I'm just going to turn the camera off for a moment to check some questions. So take a little sip of your tea and I shall be back in about 15 seconds. Right, I'm back. Sorry for the delay. Trying to work through our very tiny questions box written in 2-point font. There was a question there about something about children that could be left alone could they be left alone at a certain hour, a certain age? And I'd say to you, well, that's a matter for you, not necessarily a matter for an employment lawyer. There was also a question about to the extent staff might be less productive if they're working from home, they've got kids tearing around, can we do something about apportioning out their hours? That's a good question. Can we just park it for a minute, because I want to talk about variations of contracts in a minute, and I'll address it in a framework type way, but the answer is effectively yes, there is a mechanism that can be done. So thanks, that I think there's a couple of, if you're having technical difficulties, what I can say about that is, as I said, it is our first run at this, so we will resolve that, but all the slides will be made available to attendees at the end of the presentation. So if you miss bits, then relax, we'll send this out to you. Okay, so I'm going to try and see if I'm clever enough to get back to where I was. Right. Okay, so we were talking about working from home, done. Right, let's move on to leave. Let's start with the basics. Can an employer direct a sick employee to take their accrued paid personal carers leave? So PCL leave, we call it, commonly known as sick leave, right? So can an employer direct a sick employee to take their accrued sick leave? You'd think the answer is yes, wouldn't you? Actually, no, the answer is no. It's for the employee to request it. Technically, if you want to go and track it through in the Fair Work Act, there's section 97. It's for the employee to request it, right? But obviously, if the employee is sick, we know for WHS reasons, the employer absolutely needs to direct that sick employee to remove themselves from the workplace, and the employee is required to cooperate with that direction. So if they want to get difficult about it, then the smart thing to do is they take their accrued leave. I'll talk about what happens if they haven't got any in a minute, but for the moment, if they've got accrued leave, they should take it. If they're not going to take it, and direct them to leave the workplace. If the employee is too sick to render service and doesn't apply for paid personal carers leave, then the absence will be unpaid. If they do apply, then obviously they get paid to the extent they've got the accrued entitlement. And if they are actually they're still rendering, if they're able to work from home and they're able to render service, then they get paid, right? I hope that's clear enough. So that's if the employer themselves is sick. Next question that falls out of that is, can an employee take paid personal or carers leave to provide care or support for others who are sick with corona? So I just thought I'd remind you of where the law currently sits on that. As I said, that may well change, but at the moment, can you take paid personal carers leave to provide care or support for others? Well, firstly, the answer is yes, if you meet these three criteria. You must have accrued the entitlement to paid personal carers leave. Obviously, people like casuals don't have that entitlement, so they're not going to get paid PCL. And if you've already used your PCL for other purposes, then you don't have an accrued entitlement. So providing you've got an accrued entitlement, providing you meet the notice and evidence requirements that currently sit in the Fair Work Act that aren't particularly onerous in terms of verifying the need for that care, then you can take the leave as the law currently stands to provide care or support to, there's two categories of others, that is a member of your immediate family, the definition is quite broad, spouse, de facto, child, parent, grandparent or sibling, or a member of the employee's household. So it's pretty broad, right? And it's everything you'd expect. So an employee can take paid PCL in that circumstance. That's the easy bit. It gets a little trickier now. I've just talked about sick leave. What happens if the employee is not actually sick, but is required to be isolated or quarantined? We've got those people in our workplace. I'm sure you've got them in yours. What is the story? Here's the answer, as best as I can understand it. Firstly, be guided. Go to your framework of instruments that I talked right at the start and tick off each of those to make sure they don't provide anything that's superior to what I'm about to say, right? So check your instruments for superior entitlements. Assuming that they don't bear on it, then here's how it would work. If they're not sick, then PCL wouldn't be appropriate, right? If they're actually working from home, as I said before, they should be paid. Service equals wage. If they can't work in that isolation quarantine scenario for whatever reason, because it's just not, it depends on your business, obviously. Some businesses can work from home a lot, work in isolation a lot easier than others. But if that's just not possible, the worker isn't sick, then whether they are paid or not, you'd have to answer this question. Why is the isolation or that inability to work actually required? What's the source of it? And it seems to be, if there's a government order out, such as if you've just come back from travel from overseas, you must be isolated for 14 days. Right? That's the current isolation order. You can't work. It's not feasible for you to work from home, but you're not actually sick. Who pays? It's kind of obvious, isn't it? You don't have an entitlement. The employee does not have an entitlement to be paid there. They're not rendering the service. And the reason for the inability to work is because of the government order. It is not a direction or an initiative of the employer. So in that circumstance, there's no entitlement to be paid by the employer. Where the isolation is required because of the employer's work health and safety direction, and the employee is otherwise ready, willing and able to work, then they have to be paid. Because I did say to you, it's service that earns wages. You need to be really clear here that service doesn't just mean work. It means it's serving the employer. And if the employer directs you to work in this location or move off this premises or work over here, then that is, or not work at all, then that is still service and therefore ordinarily should be paid. That's where that currently sits. Obviously, employers and employees could come to their own arrangements about accessing leave and working from home and whatnot in that space. But as far as I can see, that's where the law, hard edge of the law sits. So, sorry, so I've called that isolation leave for want of a better phrase, but there is no such thing. Okay, so I've tackled that little conundrum. I might whiz on to just some other basics around annual leave and long service leave before I move on to talking about the issue of reducing hours or pay to cope with reduced hours of productivity. So in terms of annual leave, a couple of questions. Some, as I said at the start there, obviously some businesses will experience a downturn. Others are frantic. Presumably if you're in the IT business or you're in the medical business, I don't know, toilet paper manufacture business, you're rather busy at the moment. You'd rather your staff didn't take leave. So a couple of questions that we've been asked. Can I actually direct my employees to take their annual leave? Can I make them do it? Number one. And number two, can I decline requests for annual leave if we're really flat out? The answer to both of those questions, it comes straight out of the Fair Work Act, the national minimum standards there. the answer is effectively yes to both questions with a few qualifiers. Let me just take you through it. The Fair Work Act actually requires the parties to agree on taking leave. An employer cannot reasonably refuse to agree on a request by an employer to take paid annual leave. So you can't reasonably refuse, but if demand's out of control, then that would seem to be a pretty good ground to refuse a request to take paid annual leave. A lot of awards and enterprise agreements cover off on this issue. So in addition to the Fair Work Act, you have to comply with your award and enterprise agreement requirements. Make sure you look at that. Where the award of the enterprise agreement says nothing, or if your award or enterprise agreement free, the employer can require the employee to take annual leave where that's reasonable, right? So I would have thought a downturn in business of the magnitude that some businesses are experiencing at the moment, it would be reasonable. Comply with the award of the enterprise agreement. If your award or enterprise agreement free, act reasonably and you'll be fine. Okay, that's the story on annual leave. Quickly, long service leave is a little bit different, but essentially the answer is yes. Can I make them take long service leave? It's covered. Long service leave is a state responsibility, so you need to check out the ACT Acts there. But you're actually supposed to give your employees 60 days written notice of long service leave. It can be waived by agreement, so I think that can be worked out. Can I postpone requests for long service leave in the ACT? Again, I haven't quite said yes. I've said probably there. Your obligation is to grant long service leave as soon as practicable after the long service leave entitlement accrues, having regard to the needs of the employer's business. So there's a little bit of an out there if you need to do that. So that's the story on leave. I'm going to move now to talk about variations to hours and pay. Before I do that, I might just take a minute just to reintroduce myself for those that have just joined. This is the HR Breakfast Club run by Bradley Allen Love Lawyers in Canberra. It's a monthly forum for HR managers to come and have a chat amongst themselves to network, to learn a little bit more about employment law. It's normally a face-to-face forum on the third Friday of the month, held at, sorry, the third Friday of the month. Okay, just bear with me. Okay, if you want to vary hours or wages, there's a few fundamentals that are kind of obvious, but we just need to remind ourselves of them. Every employee has a contract of employment. It mightn't always be, ideally it's in writing, but even if it's not, you still have a contract with them and it has certain obligations and terms attached to it. But every employment relationship has an employment contract sitting underneath it. And an essential term of every contract of employment is pay, how much you get paid, and hours are also a fundamental term of a contract of employment. Employers cannot unilaterally vary a contract. In fact, nobody can unilaterally vary a contract on fundamental terms. A contract by definition is an agreement, so it's not for one party to just unilaterally say, oh no, we're not doing that anymore. Here it is. Okay, so by definition, any variation to hours or wages, either the number of hours worked or potentially even rostering, how they're worked, needs the employee's agreement as a matter of contract. So you're going to have to get them to agree on it, right? Obviously, we bargain in the shadow of, well, what if you don't agree? Then start talking about terminations and redundancies in a minute. So it's it's not really a free, we're not living in a free world here, but employers need to get their consent of their employees to effect any changes to hours and wages. So if you want to do it across the board, you're still going to have to get consent from employees as a matter of contract, right? What you can do without agreement is, if you need to, employers, you could withdraw discretionary benefits if absolutely necessary. So the extra bits that aren't contractual, and that'll depend on contracting from workplace to workplace. But you know, car parks, some sort of bonus schemes, like those sort of benefits, you want to be pretty careful on the bonus side of things, but it's something to think about, right? So just park that thought. The other thing on when it comes to varying rosters, at least, or hours for your award covered staff, there's almost always a consultation requirement in the award, and often an agreement is required as well, merely to change rosters. Say in nursing, if you want to do that, you have to get, you have to consult and you have to get an agreement. Now, that's, you ignore that on pain of breach of enterprise agreement or breach of award, right? So it has, for the moment, it has to be complied with. Can you reduce employees' hours and pay if you need to? Well, yes, as long as they agree to it, right? And if they don't, then you have to look at, well, does that full-time position you currently hold, or that position that attracts this much pay, is that sustainable in this organisation? And as I said, we'll talk about termination redundancy shortly. I just wanted to briefly touch on stand down after the Qantas announcement yesterday that they're standing down, gosh, I can't remember, it's a third or 2/3 of their staff, like a massive number. Obviously, it's a question on a lot of employers' minds. Stand down's tricky. I thought I'd just in a slide try and give you a clue as to what it actually means. At law, standing down is the employer suspending performance of the employment contract on the ground that the employee cannot usefully perform work. So that's what it means. A lot of enterprise agreements and some awards cover, and even some contracts cover, what's meant to happen in your organisation in a stand down situation. If that's the case with your organisation, you must comply with that for the stand down to be lawful. Assuming that you either don't have an award or enterprise agreement covering your staff, or you have an award or enterprise agreement, but it says nothing about stand down, then the default position is provided in the Fair Work Act. And the sort of good news is that Section 524 of the Fair Work Act, it does allow employers to stand down an employee where they cannot be usefully employed because of a stoppage of work for any cause for which the employer cannot reasonably be held responsible. So that's the test. The question, of course, is, well, is Corona a cause for which the employer cannot reasonably be held responsible? It's a little bit more complicated than that. If Corona causes a downturn of business, downturn of business usually hasn't been a basis for a stand down as such, as opposed to something like a travel ban. That is something that obviously Qantas can't reasonably be held responsible for. It's led to a downturn of business, but I think the stand down in that case, I don't know if they stood down exercising their rights under Section 524 or if they were exercising rights quite possibly in their enterprise agreement. I don't know the ins and outs of that. I do know that travel obviously is in a bit of a special conundrum, let's put it that way, regarding stand down that might not extend quite to other businesses. So I guess what I'm saying there is whether you can stand down right now is a little uncertain. And it's really important because stand down's unpaid. So it means we're not terminating the employment contract, we're standing you down without pay because we can't reasonably usefully employ you for a stoppage of work for which we can't reasonably be held responsible. It's traditionally been applied to cases where it's like a breakdown of equipment or industrial action. I couldn't find any cases that there's no precedent for what exactly will trigger Section 524 other than it, everybody wants to proceed with caution. So there's, as I said, there's uncertainty as to whether we're in stand down territory. The worse the situation gets, the closer we are to stand down being used. There is a procedure in the Fair Work Act where there's disputes about it. There's a Fair Work Commission procedure to hear disputes about whether it's valid exercise of stand down power. And I noticed the Fair Work Commission set up a little portal for applications to the Fair Work Commission dealing with any sort of coronavirus type affected matters. So there is a way to get before the tribunal if we need to about that, but obviously that's about to become a pretty live issue. I'm sorry I can't give you more certainty than that, but that's where it sits. Finally, I wanted to whiz through 10 to 9. I'm going to quickly whiz us through termination redundancies because that's actually kind of straightforward, and then I'll check any questions. So what I should say about termination redundancies is that nothing's changed in terms of the law. So what you already know about termination redundancies will apply. Coronavirus is just another reason why this issue might come to the fore. There's no new law as such, but just to remind you what that actually means. If you need to make an employee redundant, the first thing you have to do is give them notice. That notice is set out in the Fair Work Act. Probably should say, if I've got any New South Wales local government people listening in, you can just ignore the Fair Work Act references, and we'll talk about local government in a separate session. But for most of the country is covered by the Fair Work Act. So the notice provisions for your non-casual employees, you have to give notice in accordance with the sliding scale that's set out in the Fair Work Act that you're probably all familiar with, right? And whatever other instruments, if your contract says, the Fair Work Act says you get 4 weeks because you've been here, I forgot how many years it is. If your contract says more, we'll give everybody 3 months, you need to comply with your contract, right? Usually it'll say notice or payment in lieu. So that might create cash flow problems, but you have to give notice or payment in lieu. That's for your non-casuals. For your casuals, well, that's low-hanging fruit there in terms of they're employed to the end of their shift and no notice is required as a matter of law that their employment ceased. They simply don't get invited to start the next shift the next day. That's how that works, unless your instruments say otherwise. And anybody who's got independent contractors out there, I noticed somebody said a question about that. Well, the notice will be as you've expressly agreed in your service contract. And you haven't said anything about it, there might be an implied term of reasonable notice. So if you want to make people redundant, don't forget to give them notice or payment in lieu. Don't forget they're entitled to redundancy pay under Section 119 of the Fair Work Act. That's in addition to payment in lieu of notice. Small business are excluded from the obligation to pay redundancy pay, and the Fair Work Act does give, let me just move to the next slide, it gives a few outs there for employers who can't afford to pay the redundancy pay. Remember, the longer your staff have been there, the more expensive their redundancy entitlement is. There is a procedure under Section 120 of the Fair Work Act to apply to reduce your amount of redundancy pay if you can't pay. Obviously, evidence of hardship needs to be provided. It's not granted, or it hasn't hitherto been granted as a matter of right and it's not really granted just because you can't afford to pay. The Fair Work Commission looks at, frankly, will other employees benefit if they decide not to pay that redundancy pay? Will that make the business viable and thereby keep other people in the job? Those sort of considerations come to the fore in those applications, but I thought it probably just let you know that facility applies. Don't forget, consultation regime regarding redundancies still applies unless awards are varied. Then if the award says you have to consult regarding redundancies, then you need to comply with that. And it kind of goes without saying that you need to consider redeployment as well to ensure it's a genuine redundancy if you want to avoid unfair dismissal applying. So there's a couple other things I can probably ignore concerning frustration of contracts and some tricky legal issues that may well come up in the next few weeks. So I haven't by any means covered off all contingencies, nor you know, what might transpire down the track, but they're the buzz issues that are coming across my practice at the moment. I hope that you found that a little bit helpful. I'm just going to check my little question box for a minute, and then I'll just finish off with a little bit of housekeeping about where to for HR Breakfast Club next. Okay, right, I'm back. I have this impossibly small question box and a whole load of questions. It's very difficult for me to see them. And also we're just running a little bit out of time. There was one question there I thought I'd just pick up really easily. There was a question about workers' comp, and I'm sorry I haven't even touched the size of that. If an employee contracts COVID at the workplace, will they be entitled to workers' comp? Well, okay, you all know our Bill McCarthy workers' comp lawyer extraordinaire who could answer that in more detail than me, but from first principles I'd say workers' comp, if a worker suffers an injury and it's caused by work, prima facie they're entitled to compensation. Yeah. The issue is going to be causation, I would have thought there, and how do you prove that you got the virus at work as opposed to in the foyer, or sorry, you know, outside of work. In the foyer might be in work, I better not go there. Yeah, there's probably all sorts of workers' comp conundrums there still to be worked through, but theoretically, if you can prove you're injured by work and therefore you would get your compensation payments for the time you're ill and your treatment costs, you know, theoretically you're entitled to that. I haven't seen any of those coming through though, but I'll check with Bill, and if there's anything else I need to add on the workers' comp front, I might send a note through to you about that. As I said, folks, there's actually loads of questions, and I'm really sorry that we're out of time to get to all of them. What I propose, just in terms of housekeeping, is a couple of things. As I said, we'll send the slides that we have through. I'll have a look through those questions, and if there's any that I think are of interest to the entire group, I'll try and tackle all those as succinctly as I can in a note. The video of today will be available on our HR Breakfast Club website. So that's hrbreakfastclub.com.au. It's also available on our VAL Lawyers website. That's VALLAWYERS.com.au. Now, both these websites will update with helpful information as time permits. We're not making a promise to keep you up to date with the law as far as it in that regard, but if we've got anything we think is helpful that we can send through to you, we will do that. Now, our next, it's 9 o'clock, so before we all tune into the 9 AM news and hear the latest horror story, I should just let you know that, so next HR Breakfast Club, we meet on the 3rd Friday of the month. So this one's on schedule. The next one will be Friday, the 17th of April. We'll do one of two things for that session. It's scheduled at the moment. If you look on our HR Breakfast Club website, it tells you what the schedule is at the moment. We've got John Wilson, who's the Managing Director of Bradley Allen Love Lawyers and the Legal Director of the Employment Law and Investigations team here. He's doing an Ask John session, and so you can send in your questions and get some free advice on all the curly questions. We've already had them come in. He was slated for today's session. In light of the corona thing, I bumped him off, and that session will run on the 17th of April. That's option 1. Option 2, we might do Corona Mark 2, depending on how events unfold, and I can incorporate and probably develop some more considered answers to some of the questions as they're coming in and as events unfold in the next month. So keep your eyes peeled for that. I think we'll all just go and get a cup of coffee, and then we'll go and hit the day running, right? Thanks for being with me. It's been a pleasure, and I look forward genuinely to meeting you in person when circumstances permit. All the best.